Hi, everybody. This is Kevin Gormley again with Leading Edge Financial Planning. And today I'm joined with Travis Reader, who is a newer member of the Leading Edge team. And Travis is a certified financial planning professional. He's somebody that lives in the great state of Kentucky, which does make the best bourbon in the country, except for Tennessee bourbon. I live in Tennessee. But anyway, Travis, welcome today. And if you want to just tell us a little bit about yourself before we jump into the topic.
Oh yeah, I think we'll just start by saying we agree to disagree on the bourbon, but that's fair enough.
Yeah, 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 absolutely.
No, yeah, I've been a CFP professional. I actually attained my CFP certification in 2015, and prior to that, had experience working in the corporate finance world, and so really excited about joining the Leading Edge financial planning team.
All right, great. Well, Travis and I have taken a deep dive into some of the laws that affect people that inherit accounts. And today we're going to try not to use jargon. We're going to try not to teach you everything, but we're going to try to really expose you to some of the things that you might want to be aware of if you do inherit money. So, really, the first thing to mention is that when you discover that you're a beneficiary of an investment account, that the account owner has passed away after the grieving goes on, typically people start thinking like, what now? What do I need to do? So Travis, let's start out with that. What are some of the things that should be on a cross check for somebody as far as what are the things they need to do when they find out they're going to inherit money?
Yeah, Kevin. Yeah, and I think you nailed the very first most important thing to do is just go through that grieving process and make sure you're present. But once that kind of that step, you've kind of gotten through that. What we want to do on a more blocking and tactical process is to determine the account type and the
Mhm.
possible. There's all kinds of different accounts that a possible person could inherit, but the three big buckets. What we're going to try to determine first off is, was it a taxable brokerage type of account, a deferred retirement account, often called like traditional IRAs or rollover IRAs. And then the third big bucket of account types would be a Roth IRA retirement account. And for really the purposes of this presentation, we're going to decide if it's a Roth IRA or a deferred IRA type of account.
Yeah, so these taxable designations are so important, Travis, because if the account is a taxable account, for example, the beneficiary doesn't necessarily have to pay taxes on it. That money's already been taxed. You get a step up in basis, which is a fancy way of saying that nobody has to pay tax on whatever the current worth is if you were to sell it the day after somebody dies. When it comes to deferred accounts such as 401ks, traditional IRAs, rollover IRAs, that means that somebody does have to pay tax on that money before it can be consumed, spent, have fun with. And then the Roth IRA and the Roth 401k, most likely no one's going to pay tax on that. Again, tax has already been paid, it's been put in the Roth. With the brokerage account, these designations don't really matter. For the Roth account, they don't matter. And so that's the reason why it's really important first to learn about what accounts are available. So now we know what are the accounts that somebody might be receiving, and bank accounts too would be in that taxable realm. But now that we've determined that, what's the next step, Travis?
Yeah, and just one more point on that. If you do have any
Yeah.
questions about that, a lot of times once you determine where the account's held, the financial institution, you can reach out to them, and they'll be a great resource to help really pin down what type of account you're going to be inheriting. So yeah, so the next step after determining the type of account, step two is you need to determine your relationship to the person that passed away, and it may seem kind of straightforward, but there's the IRS has certain designations or classifications, so they've got some kind of a little bit strange wording. But the first one is what's called an eligible designated beneficiary, and typically that's a surviving spouse. In most cases, there's some other potential options such as a disabled or chronically ill person, anyone that's less than 10 years younger than the deceased person, or a child that's under 21. So that's what the IRS calls an eligible designated beneficiary. The next classification is what's known as a non-eligible designated beneficiary. In most cases, what we see is adult children, a child of their parents passed away, but it's most non-spousal beneficiaries. The last category is non-designated beneficiaries, and those are charities or estates, or in some cases, certain types of trust.
So now we've done, again, for these IRAs, 401ks, we've done step number two. We know if we're ineligible or non-eligible or there's no one at all. So now we come to step number three, and we're going to use some different jargon here. We have something called an RBD, and we have something called an RMD. Some people know what they are, some people don't. Can you talk a little bit about what these mean, Travis, to somebody that just doesn't know?
Sure. Yeah. And this takes us directly into step number three. And it's to determine if the previous owner was required. I mean, in simplest terms, were they required, not if they were taking distributions from the account, but were they required to make distributions from that account? And so that leads us into the RBD. That simply stands for required begin date. And so that's the date and time that which the previous owner was required to start making required, and the key word I keep emphasizing the word required to make distributions. And so the once you have an RBD, the begin date, it leads one to think, okay, there's an RMD. That's the required minimum distribution. And that's the annual calculated amount of money that must be or that is required to come out once you reach the required begin date. So it's kind of a long-winded way of just saying, were they required by the government to take a distribution from that account?
Yeah. So in the beginning, we had, we get to have a 401k or an IRA. We get the tax deduction, right? But the IRS found out that some people were never taking any money out of the IRAs and the 401ks, and then they would leave them to children, and the children would stretch the money over their lifetime. So the IRS decided we better make people take money out while they're living. So these required minimum distributions, at one point they were 70 and a half years of age. Now they can be as high as 75 years of age. But the required minimum distributions are just, you got to take money out every year. You got to pay taxes. Most people spend the money, so it doesn't matter anyway. But if you don't spend the money, you still have to take it out. So that's great. So now we come back to this. In the beginning, we had a stretch IRA, and it was beautiful. So somebody died, very sad. You were going to inherit an IRA, and then if you were a young person, 20 years of age, you could stretch that money out over life expectancy. Let's say 60 years. If you were 50 years of age, maybe you could stretch it out over 25 or 30 years. Now, the reason why the IRS didn't like this is that they didn't get a lot of tax, and then that person would die and leave it to someone else, and it would just continue. So what's the change here with the amount of time that you have to take the money out? And you can please feel free to share your slides that you made for this, Travis.
Yeah, great. I think what we'll do is just to make it a little more clear, we'll use a scenario. So we'll have a surviving spouse scenario. Okay, surviving spouse scenario, and we've just focused on the area that's outlined in red here. And so you can see this takes us right through the steps that we just discussed. We said, so this IRA beneficiary, this is already assuming that this is an IRA. So step one, check. We know the type of account that's being inherited. And so then you come down, and next step, we need to figure out, are we designated beneficiaries? And I spoke to this kind of language earlier, but hopefully this puts a picture speaks 1,000 words, so to speak. So here we go. We're coming down and we say, oh, we're a surviving spouse. Okay. Eligible designated beneficiary. So you can just see how it just flows down right through those steps. And then, so here we find ourselves at step 3, RBD, required begin date. So this is prior, on, or after. So if the husband passed away, husband or wife, the spouse predeceased, or the deceased spouse was before RMD, you can either use a stretch over the surviving spouse's lifetime or the 10-year rule, whichever is favorable. And Kevin and I were discussing when you would use the 10-year rule, and that would be if the surviving spouse was, say, in their advanced age, maybe in their 90s, and the RMD stretch would be faster than the 10-year rule. So that's a scenario where that could potentially be more beneficial. Over here on the
absolutely.
other one. Yes, sir. Yeah. And then on the other one here, it's on the after RBD of the decedent. You can stretch over whichever is longer. And just to take a step back, what we're trying to accomplish here is to stretch out to make it the required amount as small as possible in the distribution schedule, like how long you have as long as possible. That's kind of basically the technique that we're trying to achieve. And the surviving spouse or eligible designated beneficiary, they have the most options and the most ability to stretch this out and to lower the required amount in a given year. So they can either stretch 10-year rule or stretch over their life or the decedent's life. And that's kind of a quick summary of what a surviving spouse will be able to, their decision process.
Yeah, and I'll just add that, disabled persons, chronically ill persons, and persons that are less than 10 years younger than less than 10, yeah, less than 10
Correct.
years younger, then the decedent can also have this eligibility. And then children that are less than 21 years of age, they have their special circumstances. So we're not going to talk about that today. They can stretch until they become 21 and then take it out over 10 years. But if you have that situation, you can look that up. All right, so let's go on now to what we see most, which we hope to see most, and that's that a parent will die, hopefully at age 100, and the child will inherit it. And that's the way things should happen. So now we have something called a non-eligible designated beneficiary. That sounds bad.
Yeah. So we're going to talk now about, I call it the adult child scenario.
Yeah.
And it's that same chart. We're just going to highlight this middle. Again, step one, we know what kind of account it is. Step two, what was our relation? And we're saying non-spousal beneficiary, so an adult child. So we satisfy this. And then here we find ourselves back at that same decision point, or trying to figure out, did the person that owned the account, the original account holder, had they reached RBD or not? That's kind of the big kind of decision point once you get all the way down. If they had not reached RBD, the required begin date to start taking distribution, you have what's known as the 10-year rule only. And that means from the date of death, you have 10 years to get all the money out of that account. So you can wait till, the very end of that 9th year and take it all out. You can do it in 1/10 increments. You can take it all out in the first year, any combination. But at the end of the day, at the 10th year after the date of death of the person you inherited this account from, all the money has to be out. So now that one's pretty straightforward. This other one, on or after RBD. So this is the one that we just got clarification on just this summer. So you see my writing here, 2025 start. So what we have here is a 10-year rule plus an RMD, a beneficiary RMD calculation. And so actually all along they've decided retroactively, you were supposed to have been taking these distributions if say someone passed away and you inherited an account in 2022, the language still was kind of muddy and unsure. So again, just this summer, they put clarification on it that if the RMD had been started and you're a non-eligible designated beneficiary, you have a 10-year rule and you were supposed to have been taking beneficiary distributions, but they've waived any kind of penalties and then said, okay, we figured this out. Now, starting in 2025, you're going to have to start taking the required beneficiary distribution. But again, you don't have 10 years from 2025. The 10 years starts when the person passed away. So I know that's a mouthful, but just to give you a quick example, if the person passed away in 2021, all the money has to be out by 2031. But starting in 2025, if you will start having to take the required beneficiary distribution. Kevin, that was a mouthful. Do you have I know you're really good at summarizing.
Well, I'll just say this, after a few years of the law, people do start to know the 10-year rule. So people know the 10-year rule now. If somebody dies, it's got to be out in 10 years. But if it's before they started taking their RMDs, then it's just 10 years. You can take out $1 a year. You can take out none. You can take it all out in a year. If the person was taking RMDs, you gotta do a mini stretch, which just means you got to stretch for the first 9 years, and you got to use the table. I think it's the uniform lifetime table, but anyway, you got to stretch it for the first 9 years. So you're just taking out a little bit, not that much, but you must take it out, and then the 10th year it all has to be gone. So either way, the money has to be gone in 10 years. But if they were taking their RMD, you got to take it every year. As Travis said, 2021, do over. 2022, do over. 2023, do over. 2024, do over. So really, we're starting this in 2025. So good work. Good work, Travis. Good work.
Oh, thanks.
So now we're going to talk a little bit about key takeaways. So, what do you think if a pilot is watching this? We don't just have pilots that watch, but if a pilot's watching this and they want to jot down some notes or have a checklist, what are the key takeaways you think, Travis?
Yeah, I think the first thing is just to kind of broadly understand what the IRS is trying to accomplish with these rules, the required minimum distributions, why it's different for different types of beneficiaries, is to just to take a step back and understand that these retirement accounts were set up with special tax treatment and a deferred IRA. It means when the original owner made a contribution, they got a tax deduction. So the IRS says, okay, at some time in the future, we're going to require you to take some money out so that they can tax the money, just to be perfectly blunt. And so you can see that to the original owner, it's pretty beneficial. They wait till, they're into their 70s and before they require them to start taking it out. And then if they do pass away, the IRS says, okay, if you're a surviving spouse or that type of beneficiary, we're not going to be so aggressive on how fast you need to take the money out. So again, the whole thing is the faster the money's required to come out, the more taxation that it's going to be exposed to. So that's kind of at the highest level of trying to understand what the whole goal from the IRS's perspective.
Yeah, so I mean, really, the keys is to understand the person that died. Were they taking these required minimum distributions? Yes, no. That's the first. The second is who are you in comparison to the person that died? Are you a child? Are you was it your spouse? Was it an uncle? Were they your brother that's less than 10 years? And figuring out if you're one of those eligible or non-eligible designated beneficiaries. You don't need to know what that is, but just figure out your relationship. And you can, I'm sure there's going to be calculators online to try to help you figure it out. And then if the person did not leave the money to anyone, well, then you got the least favorable, the 5-year rule. So always a good reminder to say, if you don't know who your beneficiaries are, check it. It's a good idea to check it. The final category, the other key takeaway is if the person that you're inheriting the money from already went through all this and was inheriting the money from someone else. I mean, that would be the worst of luck, where one person dies, they inherit the money, they're on this either stretch or they're on this 10-year rule. But if they're on the stretch, your 10-year rule starts when they die. And if they already were on their 10-year already, then you need to take it out and fulfill their 10-year. So this gets really muddy. The final delineation and takeaway is to understand if it's a Roth IRA, traditional IRA, or if it's a 401k or other types of plans like that, because again, there are some different rules. So really our job today, and we hope we were able to do it, Travis, is at least get people to think a little bit about, what should they be thinking about when someone dies and they're going to inherit money? What do you think are the key planning opportunities for either financial planners or for clients with their family?
Yeah, that's a great question. And what we like to think about is, generally speaking, it's best to select the distribution option that stretches it the furthest and makes the required amount the smallest in any given year. And that gives you the most flexibility, because we love to focus on tax planning and making sure we're efficient with income and all those kinds of things. And whatever options afford it to you, whatever your designation is as a beneficiary, whatever option you can select to make it be the longest possible that you're required to take out, that is the best option to start with. And then once we've established it, so once you've established your beneficiary required minimum, that amount's been established. It's kind of that's going to start coming in every single year. And then at that point in time is when it's a good idea to take a closer look at your projected annualized income and determine if you should take more or not. And that may sound a little bit kind of kooky or foreign, but sometimes it's better to show income sooner than later. And those are when you want to get with a tax professional or a qualified financial planner to try to help you answer those questions.
That doesn't sound kooky at all. I mean, if you have a year where you give away $100,000 and you're not working, that's a year to take money out of an IRA and establish a little bit of income that's taxed at, very low tax brackets. Now, if you just got the retro bonus or whatever bonus from your airline and your income is now 600,000 and you have the choice of accelerating income or not, obviously don't accelerate. So there is a little bit of planning. It's not all about always delaying, but for most part, Travis, I agree. You always want to pay for taxes in the future, and you want to pay with inflated dollars. So absolutely. So, is there anything else, Travis, that you think is important before we call it a day?
Yeah, I think that covers most of it. To give you a Mark Twain quote, he said, "Death, taxes, and childbirth. There's never a convenient time for any of them." So,
Yeah, and at least two of those come for all of us, and I do think it's important just to pause when someone passes away, and just figure these things out. Usually it's your brother or somebody else that's telling you hurry up and do this, or maybe you're thinking about getting a new boat. It's funny. Mom or dad would have wanted me to have a new boat. But anyway, Travis, thanks so much for joining us today. And if you have any questions or comments, please reach out. Travis, let me share our screen there, the information on how to contact us. And here it is. You can reach Travis 865-895-5203 or Travis at leadingedgeplanning.com. And my number is on there as well, or Kevin at leadingedgeplanning.com. Travis, thanks so much for joining today. Appreciate all your insight and your great understanding of this situation.
thank you very much, Kevin. Everyone have a great day.
Leading Edge Financial Planning, LLC is a registered investment advisor. Advisory services are only offered to clients or prospective clients where Leading Edge Financial Planning and its representatives are properly licensed or exempt from licensure. For additional information, please visit our website at www.leadingedgeplanning.com. The information provided is for educational and informational purposes only and does not constitute investment advice, and it should not be relied on as such. It should not be considered a solicitation to buy or an offer to sell a security. It does not take into account any investor's particular investment objectives, strategies, tax status, or investment horizon. You should consult your attorney or tax advisor. The views expressed in this commentary are subject to change based on market and other conditions. These documents may contain certain statements that may be deemed forward-looking statements. Please note that any such statements are not guarantees of any future performance, and actual results or developments may differ materially from those projected. Any projections, market outlooks, or estimates are based upon certain assumptions and should not be construed as indicative of actual events that will occur. All information has been obtained from sources believed to be reliable, but its accuracy is not guaranteed. There is no representation or warranty as to the current accuracy, reliability, or completeness of, nor liability for, decisions based on such information, and it should not be relied on as such.